The Learned Council has further submitted that the has further relied upon the judgment passed by this court in LPA number 391 of 2009, Messrs. Sujata Picture Palace Ranchi versus Jharkhand State Electricity Board, decided on 9/8/2010 to submit that merely because the gadgets were installed in the premises, the same does not mean that the petitioner was found using all the gadgets at a time. He submits that merely because he submits that nothing has been mentioned in the inspection report that these gadgets were connected to the line at the time of inspection. He has further referred to the counter affidavit and has submitted that in paragraph 10 there are allegations which do not find place in the inspection report, wherein it has been stated that the petitioner is running a workshop for preparing sweets behind his house for selling through his shop located at Bumla in a name and style of fun and food, and many heavy electrical equipments have been installed for that purpose. He submits that the inspection report does not reveal any heavy electrical equipments, and the gadgets found are routine gadgets which are found in a house. The Learned Council submits that the action of the respondents is especially illegal and not sustainable in the eyes of law. Consequently, the load inspection bill is put to be satisfied. He has further submitted that the petitioner is liable to pay the units consumed through its meter, as there is no allegation that the meter was ever found defective. The Learned Council, appearing on behalf of the respondents, on the other hand, has submitted that it has already been recorded in the inspection report that a sweet workshop was running in the camp. He has also submitted in the compound, camp में compound है ना, photocopy में देखे थे, CMP नहीं, COMP.
No, in the inspection report it is mentioned COMP.
COMP.
Yes.
Campus भी हो सकता है.
Campus भी हो सकता है.
ऐसे लिख दिए होंगे. He has further submitted that since two pump motors were used, therefore the connection was converted into non-domestic category. The Learned Council has submitted that for the purposes of domestic category, motor pumps for lifting water up to 1 bhp for domestic purposes and other household electrical appliances. क्या लिखें? The schedule shall apply.
not covered under any other.
Appliances not covered under any schedule. However, during the course of argument, it has not been explained as to how the pump motors, which were 2 in number, could be set one bhp का क्या है?
Horsepower, not so that is the unit.
Bulk horsepower. How much is that? दोनों मिला के जोड़ दिए ना?
Yes, दोनों मिला के
The learned counsel
nominally
submits
crosses
that
1 bhp.
the learned counsel submits that if both the pump motors are added together, then it will exceed 1 bhp. Yes. Further submitted that so far as the definition of workshop is concerned, he has not been able to lay his hand on any provision under the tariff or under the Electricity Act 2003 or the rules made thereunder to define as to define the workshop. That's all.
Lordship, reference to page 38 as to applicability of non-domestic.
The learned counsel submits that the however, the non-domestic service is applicable to workshops as mentioned in the tariff itself. After hearing the learned counsel for the parties, before proceeding further, it would be relevant to quote the provision of the tariff which has been relied upon by the respondent. इसको यहाँ से quote करेंगे. Annexure 4 में यहाँ से right? Mark page number 36 and page number 38. This court finds that upon perusal of the inspection report dated 19/7/2010 at 4 p.m., this court finds that the gadgets which were found on inspection included one geyser, 13 CFL, 8 fans, 1 mixie, 5 bulbs, 3 tube lights, 1 refrigerator, 1 electric iron, 1 television, and 1 exhaust, and 2 pump motors of 750 watt and 375 watt respectively. The inspection report does not reveal that any heavy electrical equipments were found installed in the premises of the petitioner. Each of the pump motor was less than 1 kV. This court is of the considered view that this court finds that in the judgment passed in the case of LPA number 391 of 2009, decided on 9/8/2010, the term connected load has been considered in paragraph 2, 3 and 4. this court finds that although in the inspection report, 2 pump motors have been found of 750 watt and 375 watt, but there is no allegation in the inspection report that they could be simultaneously used in the premises, nor there is any allegation that these 2 pump motors were being simultaneously used. Otherwise also, each of the pump motor had the capacity less than 1 kg. There is no such provision in the tariff which disentitles a consumer to have multiple gadgets, each gadget within permissible horsepower. HP is horsepower.
Horsepower.
So far as the other gadgets which are found, they were also related to regular domestic consumption. This court also finds that there is no allegation in the inspection report that any workman was found in the premises while preparing the sweets. It is not the case of the respondents that the place of inspection was also the point of sale of the sweets. As per the arguments advanced by the respondents, the workshop by itself has not been defined. In such circumstances, this court is of the considered view that merely because some sweets were being prepared in the house which could be used in the shop for sale, the same will not convert the house into a workshop. In order to bring home the concerned category of non-domestic service, the respondents or the regulatory authority ought to have clearly defined the workshop. Considering the totality of the facts and circumstances, this court is of the considered view that the load inspection bill as contained in NHA 3, which has been raised on by converting domestic category into non-domestic category, cannot be sustained in the eyes of law, and accordingly the same is set aside. However, the petitioner shall be liable to make payment with regard to the units consumed under the domestic category.
There is only one thing. The interim order was there in my favor that if I deposit 50,000, my electrical connection shall be restored. So that adjustment has to be carried out by them.
In view of at this, the counsel for the petitioner has submitted that pursuant to the impugned order, an amount of rupees 50,000 has been deposited by the petitioner.
Yes.
The amount so deposited by the petitioner will be adjusted against the regulatories. Who will do the adjustment?
Yes, ma'am.
Who will do the adjustment?
Let's the electrical
The
executive
needful
engineer
be
see
done.
that.
The needful will be done by the respondent number 4 within a period of 1 month from the date of receipt of the copy of this order. And a final bill taking into account all the payments made by the petitioner up to date, should be prepared and handled.
Yes. Much.
ये supply code. ये फैक्ट्रीज एक्ट आपका है?
It's other.
Item 4, WPS 7796 of 2012.
You are for the petitioner?
The award impugned is at page 127 annexure 7. This is a common award in two cases. Page 127.
This writ petition is connecting.
This writ petition is for both the reference cases. Reference 21 of 1998 and reference 31.
You mix up all the cases. How do we decide? Two distinct cases.
Only some persons are different. The evidence is common, and it relates.
Evidence is common for both the
Evidence is
cases.
common for both the cases. Only in the first reference there were 2 workers. In the second
Reference,
there were 5.
reference 21 of 98.
21 of 9.
21 of 98. How many workmen?
2.
2. Could you please give the name?
They Upendra Kumar and Ramesh Kumar. Respondent 1 and
Respondent number 1 and 2.
1 and
What about the other one?
the other
Reference
3 to 7 are in the other.
31 of 98. 3 workmen.
3. No, there are 3 to 7.
4 workmen.
Respondent number
5.
3 to respondent number
There are 5.
3 to 7.
5.
3 to 7. Okay. 5 workmen. All right.
Both the terms of reference have been reproduced in the award. Both are similar, both relate to a case of retrenchment as well as regularization.
So through this terms of reference, the issue of retrenchment and regularization
Both have been considered
Give
as a
us a few
specific.
dates. Give us a few dates. Since when this workmen were working?
They were working from 1/9/1985.
Okay. 1/9/1985. All together, all the workmen, right?
All the
7 working from 1/9/1985. Discontinued when?
1/9/85 to 31/8/86.
To 31/8/86.
86.
When was the reference made?
The reference is 1998.
1998.
1998.
How many years? 12 years.
12 years. So in fact, the background is that previously they had raised industrial dispute after 7 years.
Industrial disputes on what?
Regarding their illegal retrenchment.
Reference case number?
No, that was not a reference. The dispute was not referred.
Okay.
After which they filed writ petitions.
And then the matter was referred.
And the writ petition, the refusal to refer was upheld, but there was a direction that they claim that they have been working on the date when there was a scheme of the management providing for regularization, which provided a cut-off date 2/5/1986.
2/5/1986.
6/5/87 is the regularization circular, which says that all those workers, that is an extra one. 6/5/87.
Regularization circular. This is the cutoff date.
Cut-off date is 2/5/86. So all those who have been working for more than 3 months
On the cutoff.
on the cut-off date will be entitled for regularization under this.
Just a moment. So they claim that on the cutoff date they were working.
On the cut-off date.
It is their claim.
Yes, this is their claim. Only 1 year they work.
That's right. But on the cutoff date they were working.
That is.
Still they will be covered by the circular.
Yes, the circular says that those who have completed 3 months on 2/5/86,
Completed
they will
3 months.
yes, they will get the benefit of regularization
Regularization.
under the benefit of the scheme.
Then what was your case? Then in the writ petition. Where is the
Yes.
writ order?
The rate order, Lordship, I'll have to check the LCR. The rate order is not there.
Writ number?
Lordship, CWJC 1947/1995 R.
CWJC number 1947 of 1995
95 R.
R. Date of disposal? इसका date of disposal. Date of disposal check.
And this one.
15/7/96, madam. 15/7/96.
15/7/1996. And then
8/1/29.
when did you raise the industrial dispute? Thereafter for regularization and this.
No, by terms of this order, they had to make a representation to the management directly.
Okay.
The industrial dispute not being referred was not interfered with in the writ petition, but it was said that since you are claiming benefit of regularization, you file a representation and the management will consider it decide.
But they could file a representation. इसका record में order check.
So they filed a representation on
That was rejected on third.
Representation when?
2/8/98
2/8/1998.
and it was decided rejected on 31/12/1998.
1998. And the terms of reference also referred to 25F.
The terms of reference refers to termination. At least the terms of
Termination or 25F in contravention of section 25F.
25. Yes.
So terms of reference is not referring to your rejection of representation.
Yes. No, but they are taking that rejection of representation as a cause for raising a subsequent industrial dispute, which is referred as this reference. Because we rejected their representation, they treat it as a fresh cause of action, and then they raise another dispute which gets referred as
So-
reference 21
So this was the dispute which they wanted to be
Wanted.
referred earlier,
from the inception. Yes.
prior to that order of the writ
Yes.
court. You did not
Reference-
challenge the reference?
No, we have not challenged this reference during its pendency.
What is, now you argue your case.
The award,
What is the illegality in the award?
the illegality in the award is that even earlier in the representation which was filed and rejected, the management stand in its written statement throughout has been that these persons never worked in the corporation. In both the cases, identical WS has been filed. Our case is that they never worked. They are claiming that they have worked on the strength of a certificate given by one RC Sinha depot in charge, who has issued the certificate fraudulently and who was proceeded against in a disciplinary proceeding by the management. Para 18 of the WS. 15 and 18. 15 is general denial, 18 is specific regarding initiation of disciplinary action against RCC.
This is para number
This is para number 18 of my
18 of
WS.
WS. Where is your WS?
The WS is annexure 3. Starts at page 35.
Para number would be para
It's
18.
para number 18. At page 46.
Yes.
That apart from the said legal bar, the claim of the concerned workmen cannot be entertained on the basis of the document managed by them from the depot in charge Shri R.C. Sinha, against whom a departmental proceeding has already been initiated on the charge of issuing bogus and collusive attendance certificate for illegal gain.
Did you depose?
Uh,
before
This
the court?
R.C. Sinha never deposed. Only his certificate has been used. Para 19 is also important because there is another fact relating to one of these respondents, Manoj Kumar, who also claims to be a casual worker. Regarding him, there is a statement that during the particular time, Manoj Kumar, who claimed to have worked as laborer during the period 85-86, was doing his MBA course in L.N. Mishra Institute of Economic Development and Social Change, Patna, in the said
These
period.
things were proved. These things were proved.
This was not proved, but there is a statement.
Please don't. We are into 26. Just to
We are in
27.
226.
So
We
please don't.
understand that
Please don't.
we
Okay.
are
What
in.
was the stand of the workman in the written statement?
So their stand is that they have worked for only 1 year, 31, 8,
That is the
85 to
specific case.
86,
What
1
about
year.
the attendance?
Regarding the attendance register has been produced, which was maintained by R.C. Sinha, in which their signatures are not there, but they've been shown absent, present. Their details have been mentioned, and all of them have been shown to have worked for more than 240 days in that 1 year.
Okay. Let us see their written statement.
Their written statement. It is annexure 4 and 4A, two written statements. You can almost identical. It is at page 101.
One zero one.
101. Annexure 2.
Para 3, can you read?
Para 2 and then para 3. That the concerned workmen were paid their wages by the management of FSD Patahi and their attendance was being marked by the staff of FSD Patahi. They were not allowed to put their signature in the attendance register and the staff of FSD Patahi used to mark their attendance by putting A and P. A for absent, P for present.
Who has deposed on behalf of the workman?
None of the workmen have deposed.
And what is his evidence?
Yes, the evidence, there are two witnesses. One is a retired employee. The evidence is that page.
So their case was they were not allowed to put their signature on the attendance register.
Yes.
And somebody else was putting absent or present.
Yes, the depot in charge.
The depot in charge.
The depot in charge was marking the attendance, he was only putting A.
Okay.
That is the attendance.
And what is the evidence?
The evidence is
Has somebody said?
WW1 is annexure 6A, page 121. He is a watchman. So one retired employee and one watchman has deposed.
What is the statement?
His statement is, I was working as watchman at Muzaffarpur from 1488. I am working as regular watchman on the basis of award of this tribunal. I have been regularized. Before regularization, I was working as casual labor. The concerned workmen were working there prior to my engagement. Before their termination, no notice or notice pay was given to them. Our attendance were being marked by the management. The concerned workmen put their attendance for more than 240 days. Ramesh Chandra Sinha, R.C. Sinha, was the depot in charge who were working there. Till now, the post of watchman is vacant in FCI. This is under signature of Mr. Sharma, marked exhibit so and so. These orders for regularization issued by management, exhibit so and so, demand of concerned workmen for regularization is justified.
So,
And then the second witness is, of course,
so
it is,
he enters into picture only from 1488.
yes,
At the relevant point of time, he was not there.
yes. He says, prior to me, they were working.
Yes.
I have come after they were working.
Okay. What about the next
The
one?
next one is a retired employee, Lal Chaudhary. It is at page 123.
He was contemporary.
He was, he has not disclosed clearly when he was working, but he's just one paragraph he says that I retired on 31/5/2000. He says from 1975 I was visiting Muzaffarpur for official work. There was ARDC go down at FCI at Patahi, Muzaffarpur. R.C. Sinha was in charge of that go down. Casual laborers were engaged in FCI. The concerned workman was working as casual laborer at Patahi go down. Attendance was being marked by a depot in charge of casual laborer. Attendance register will show how many days a particular worker worked. Shri M.L. Sami was the regular district manager of FCI Muzaffarpur. He had written letter to FCI for regularization of concerned workmen. Workers who were engaged after retrenchment of the concerned workmen, they have been regularized. A circular was issued by FCI for regularization of workers who have done 90 days as on
You see,
2/5.
so far as their work is concerned, They have produced their register, whatever. Some attendance is not. It is not only the certificate, but it was also supported by the register.
There is an attendance record
Record.
maintained
Is
by
there
R.C.
maintained?
Sinha and his certificate that they are working.
We do not know who maintained it, but they say that the management used to maintain it. And therefore, there is some evidence that they have worked for this period. So, how do you what is the nature of award?
The award is for reinstatement, reinstatement with 75% back wages and regularization in service as class category 4 on the post of watch.
75% back wages.
75%. So my first attack is on the point of back wages. There is absolutely no evidence. The workers have not taken the stand, and it is a case of no evidence, and therefore to the extent of awarding back wages, nor in the award there is any discussion as to why it is being limited to 75% or not a lower percentage of back wages, and why they should be given back wages. On that there is no evidence, and therefore when there is a case of no evidence, the finding which is not supported with evidence is perverse.
They will say that once the termination is held to be bad, the back wages was to be given 100%.
Even if the termination is held to be bad, they have to at least plead and prove, at least make a statement even in their WS that they have not been gainfully employed elsewhere. So,
no evidence to that.
No evidence at all.
Not even a whisper.
I have not found that. You can point out.
They will say.
Yes, they have not taken the stand at all. So there is no question of making a statement in the evidence.
It's a long gap. It's a long gap also.
It's a long gap, but none of them have taken the stand to give evidence that I was not gainfully employed. They did not depose at all. They choose to stay away. The only witnesses are a watchman subsequently employed and a superannuated employee. They are the only two witnesses.
Superannuated employee was cross-examined or not?
Yes, cross-examined. 120.
Let us see.
Annexure 6A.
Page number?
Sorry, Annexure 6B, 123. No, he was not cross-examined.
He was not cross-examined.
He was not cross-examined.
Rather, he never appeared for cross-examination, as I see from the record.
Yes, he was not cross-examined. Only the first one was cross-examined. He was not cross-examined.
First one was cross-examined and discharged, and then it just went for judgment.
Yes.
Examined on prayer, the witness. On prayer of she said the witness is deferred, put upon such and such, but cross-examination of WW1 and WW2,
Yes.
right? Then then Surajdev Sharma cross-examined,
He was cross-examined.
but there is nothing mentioned about the cross-examination of WW2. His appearance is also not recorded, that he appeared or whatever.
Straight away after that, written argument.
Yes. Although there is a specific order that he would be cross-examined. Yes, what else do you want to say?
Management slabs also, they never find the recall, they did not cross-examine. Although his testimony is not of much importance, he is not giving any specific particulars. He is saying, I used to visit these people who were working, their details must be in the attendance records. So there is no direct evidence so far as the second.
He was not a co-worker.
He was not a co-worker. He was not posted at Muzaffarpur. He says in the course of visits he saw. And how does he identify or know them? Regarding that also there is no disclosure.
Anything else?
So regarding back wages, there is no material on which the back wages have been given, and there is a judgment. RBI versus Gopinath Sharma, para 22, which says that if no evidence is laid, then back wages is not automatic, and on the contrary, the principle of no work, no pay applies.
They were engaged on casual basis?
They were engaged on casual basis. Is there a case that we were casual basis, used to do odd jobs, cleaning, sweeping at the depot, fumigation work,
Anything else?
on and off. To support it, Lordship, on perversity, there is a judgment from the Apex Code 2019, General Manager Electrical Bengali, that if there is no evidence to support a finding, it can be treated as perversity, paras 26.
2019 volume?
10 SCC, page 695.
690.
I have a copy.
Para number?
Paras 26 and 27.
26.
While deciding the scope of certiorari jurisdiction.
No evidence amounts to perversity.
So far as regularization is concerned, my learned senior friend will rely upon Harinandan case, which is of the same corporation, FCI, and which arises from our own High Court, in which there was a direction that if the scheme provides, you have to regularize if the conditions are found to have been fulfilled. But after that, and there is also some dispute regarding applicability of Uma Devi to industrial adjudication in UP Power Corporation, Bijli Mazdoor Sangh, and the subsequent judgment of Maharashtra State Road Transport Corporation versus Castorai and some other cases. Harinandan was based on unfair labor practice, but there is a judgment by which this issue, noticing that there are different judgments with different opinions, it has been referred to a larger bench in a 2020 decision. ONGC versus Krishan Gopal, however,
because it has been referred to,
it has only
that
been
doesn't
referred.
take us anywhere.
Yes, it
There
does
is a
not.
judgment for your own corporation.
Yes, so
So
I
if
am
they are-
completely bound by it. I
If
have
they
no
are,
option. to
you are a party to that.
Yes.
If they are identically placed as compared to others, provided they have proved that they have actually worked,
Yes.
then you cannot deny them.
And on the perversity aspect, the only other argument that we can possibly make is that our contention regarding Manoj Kumar and the fact that R.C. Sinha had given a forged certificate, because that is the basis. While the industrial adjudicator accepts the certificate, there is no discussion regarding the contrary evidence from the management as to whether what is the effect if he has given a fraudulent certificate. That has been completely shut out. Not mentioned anywhere in the award that this person
What
was
happened? You
prosecuted.
ultimately dismissed
He
it?
was ultimately dismissed.
Yeah, has it come in the record?
Lordship, it has come in the cross-examination, Lordship. His suggestion was made that you know that he has been dismissed. Dismissal letter, disciplinary
Okay, but
proceedings
still-
have not been filed. Only in the cross-examination of the first workman witness, there was difference.
That's all?
That is.
Yes, madam, you are.
Yes, sir, again, I want to have one last point. So for the 17th, my case is, my submission is against the two reference case. The award, though award was analogous, but two reference case, the award should be challenged in the two.
Now, madam, this matter is pending since 2012, right?
Well,
Yes.
yes,
And there is common evidence, we will not go into that. You have also availed 17B in this particular proceedings only, all of you. Now you cannot say that that writ petition will not lie. So you
no,
forget
no,
about
I
it.
say my life.
You have availed
Award.
17, madam, please appreciate it. You have availed 17B out of orders passed in this particular writ petition only.
Yes, yes, yes.
Then if we say that it is not maintainable, then you have to give back entire 17B. Are you ready to do that?
No, my the law is.
Therefore, both the
My,
parties have acted upon by virtue of the common writ petition filed with respect to. So we will not enter into that. You just say what you have to say on
and
it.
so far no evidence that they are not gainfully employed, that has never been said, that is totally wrong and contrary to the record, because 17 just now say, and that is on record also, that 17 petition was filed on 27/7/2018 and 16, sorry, 16. The award is looked this way. The several dates are important and not kindly. And some the dates which have been narrated by my learned friend is not absolutely correct. Therefore, I want to say that is on record 1885 they were appointed. 1885. It says 1985. No, 1885.
Okay.
And they were stopped from work on 1986, more than 1 month. And reference was made on 11/6/1978. In between the period that is admitted
1998.
back,
1998.
98, 98, 98 references.
Yes.
In between the period, the so far the detail is concerned, that has already been placed by my learned friend, but they filed the writ petition, that is on record. They filed the writ petition, that is CWCC number 1947 of 1995, in which the 15/7/1996 was disposed of, and there was a direction to consider the so for the policy decision is concerned. They made representation and that was dismissed or rejected on 13/12/1996, page 30, 130. And see that.
That's right. You see, you made a reference regarding your discontinuation, right? That.
It means difference is 25 days.
Just a moment. In the earlier writ petition, madam, please listen to me. In the earlier writ petition, you had yes. In the earlier writ petition, the union had.
The case of the management is that paragraph 3, 129. The case of the management is that in accordance with the order dated 16/7/96 passed by the Honorable High Court Patna Resident in CWCC 947 of 1995 are the management on receipt of the presentation by the correspondent following examine the claim of the media from the documents that exist in the office, and it was found that the concerned person was never able to name the capacity of the district officer Madhumatu by name and number, though under that and never worked for certain. But though it has not been good, rather attendance is there that has been good that they have worked that is good. And they have accepted non-compliance of the next page, my last 130, that is the piece of report line. There was no question of considerable regularization in connection with the policy decision 6587. The senior manager Patna on the basis of the inquiry report, district manager passed the order dated 13/12/1996 rejecting the representation. And 1996 they reject and 1998 they consider. Therefore, there is no detail on part of the question or thing.
You see, so far as your termination is concerned, the reference was ultimately refused. And now,
Minor time is considered, but there is a direction to consider the matter and pass the speaking order. Therefore, they pass the speaking order.
consider the matter regarding regularization. Consider the matter regarding regularization.
No statement, there is no position for regularization. There is a direction to consider the matter whether they are entitled for the regularization or not. And it has been rejected on 13/12/1998. In 1998, the reference has been made that whether the termination, therefore, minor they have not challenged the award, the reference. Reference, when the reference is being referred for ratification, it is the statutory duty of that industrial court to decide the matter.
That's right.
And they have decided the matter.
That's right.
Then my lord, what is the terms of the reference? Can you see that?
No, we have seen that, madam. I get your point that the reference was made. That has to be referred. That has to be answered. There is no question of challenging the reference, right? There is no question of res judicata, and
So far delay
you come to the point straight away. You come to the point straight
Sir,
away.
I am in the point. There is no delay.
That's right. I have understood that there is no delay.
And kindly consider the argument that it has not been based on the evidence of report that is not correct and that is contrary to the document and exhibit which was before the one page 151 evidence has been established.
Page number
Evidence has been 131.
of the impugned award
Yes. Yes.
131. Yes, please.
Yes. Both the parties have filed the written statement which under paragraph 5. The management produced NW1 such as such name and two document number NW1 to NW3. The concerned workman to WW1, Suranto Sharma WW2, Ram such and such notary and documents have been marked as exhibit 1 to exhibit 21. And what document I have submitted, that is on the part my was for record. I have submitted so many awards in which the same certificate who have completed 90 days on 2026. They have been regularized, and there is several vacancies. All in certificate. That is the list of the documents filed by the workman that has been exhibited. Attendance register. I could that is in the law court record itself. Attendance register of FSC in respect of the concerned workman dated from 9 August 85 onward daily attested, duly attested by ML Banerjee and supplied by the management of the XPI. The first document, list of the documents which we have I produced. Then my reported personal details 1987 and 9996. That is so far regarding regularization of the service. Not included that the circular 1987 that who has completed 90 days on 2/5/86, they will be regularized. And several persons have been regularized on the certificate of the document. And my lord, occupancy position. Based on that point, who matters is relevant for deciding this case, whether the circular was interpreted for the same and similarly situated per se, and whether there was a vacancy. And the so far vacancies for the W5 we have stated, top position of the Bihar region, showing vacancy position of category 4 for the period from 1998 to 1998. Then my lord, Assistant Labor Commissioner FCI report part 2 of the Assistant Labor Commissioner ID for illegal replacement and non-regularization. That is the failure report. 4. And list of the documents and copy of the letter dated 35/95 issued by the applicant report superintendent about the concerned partner. Copy of the letter 19/95 issued by the district manager at Muzaffarpur regarding regularization of the concerned partner. There is a direction and there is a letter and recommendation for the regularization. Then file copy of the letter dated 17/95 issued by the regional office under the signature of the Devi Raja for senior regional about the concerned partner, their work and supervision. And copy of the ministry lemma dated 13/94 asking for comment from HCI about the concerned partner. And comment of the management of the SCI to the ministry lemma regarding ID of the concerned partner. That also is received. Copy of the award, that is most important. Copy of the award CGP1 for independence case number 95 of 96. In respect of the Uday Narayan, Uday Kumar and 15 others of the SSC Patani. That is also on record and there is as many as 50% has been regularized. That has been exhibited under W1. W1. And the notification, reject notification as of the award that was executed before the court. And the findings is that they have terminated in non-compliance of the 25 case and they have completed 90 days. Therefore, they are entitled for the regularization. Page 24 of the first exhibit W1. So for the question of payment of back wages concerned, no specific date has been mentioned about the replacement and regularization for the workman difference, and it is there also that the workman was forced to sit idle but the illegal arbitrary action of the management, and as such they are entitled for the back wages. It is also true that as per principle no pay, the concerned workers have not worked for the management, but I apportioned items clear such as the the year such as such report was saying.
That's right, madam. There is evidence on record. There is evidence on record, and there is ample discussion that you had worked for a period from 1/8/1985 to 1/9/1986.
Yes.
Right?
Yes.
Some of them were just a moment. In reference case number 31 of 1998, they were discontinued with effect from 1/8/1986. And in the other reference case, they were discontinued from 1/9/1986.
And first exhibit W1 is under reference case number 94 of 96. 94 of 96. My lord, may I pray, my lord?
W1 is 94 of 96. What is that?
That is the reference case, my lord, 94 of 96. That is exhibit W1.
Okay. Where other persons were regularized.
Yes, my lord. And can you consider what time they are paid? Can you see the award? There is 16% change. Have you not got it? Not for report.
I don't get it. Where is that? Where is that award?
Yes, that's a.
Where is that award?
They have so that has
No,
been
you are
called
referring it. They are not referring anything. You just tell us.
I have the copy of that law court report. That's why
You do not know. If
law
it's,
court report was called for that.
so there should be somebody should be there to point out. No, your junior counsel is also not here.
On the next day,
No, not on the next date. We are going to conclude it today itself.
My lord, how I shall show that?
We'll see. HCR has come?
Document.
Yes.
Yes.
Okay. Which exhibit is that? Page number? You just tell us the page number.
That is exhibit W1.
Exhibit W1. Okay.
Yes, reference case number 94 of 96. They have called for the reference, call for the record. The trust is in that. And 16,
Your junior is also not here to point out. Show us that document. So you must have seen the records.
Can you see the order?
She's not
This is
aware.
my lord. In this case, the order was passed on 17 7/2019, call for the record.
Records have come, madam. Somebody has to point it out to the court, show it to us. The records are here. Your junior is just ornamentally standing over here. She does not know anything.
There is no time also.
No, we are here. We'll conclude it. We will see
But
it.
how I will conclude that?
Madam,
document I have to
just
go.
a moment.
I have to go. Yes,
Okay.
madam. How I shall continue just now? I completed just now. Can you see that?
We are hearing you, madam. You can continue your argument.
Then my main point is that whether same and similarly situated person has been neutralized or not.
That's
I want to say from the reference case number 94 of
They
the-
do not dispute that same and similarly situated persons have been regularized. It is not in dispute. Are you disputing that? No. They are not disputing that.
They are not in dispute.
They are not disputing. They only say that you have not proved your attendance properly, and the person who had issued you the certificate, that person was under a departmental proceeding, your departmental inquiry, and he has been ultimately dismissed. This is what their argument is.
Then I want to show from the
Now you tell us
whether
one
they have-
thing. Now their entire case hinges upon back wages. So for the purposes of back wages, you have referred to the petition filed under section 17. I just want to know from you. I just want to know from you. Is there any material in the records of the Learned Labour Court regarding your employment? 17B, I have got it. There is an order under section 17.
Yes, not problem. Attendance register also proof. Attendance register also proof.
No, attendance register proves that you have worked till 1986 or 1886, right? What happened thereafter? Because he has given you back wages to the extent of 75% from the date of discontinuation.
That is the law. That is the law. That is the law that each adjustment has been made from non-compliance of the order, then they are entitled for the back wages. But whatever may be 75% back wages.
For non-compliance.
Odinandan Prasad case is also 2014 column 7193 that if there is a circular, if similarly situated person, if there is a circular, if several persons have been given the benefit of the regularization, then the matter will be on that line.
He is not,
And
you see,
vacancy is there.
these are two different things. That you are entitled for regularization is one relief. You are entitled for back wages is another relief. Right? So he is arguing on the point of back wages. What do you have to say on the point of back wages? Because the finding is that there has been a violation of section 25F of the Industrial Disputes Act.
Yes.
Does
That
it-
is not
Does it amount to automatic grant of back wages under section 25F?
My submission yes in terms of the order which has been passed in the Odinandan case and it is the second thing that the judgment was considered in that BSNL case, page 17, and under what circumstances that will be considered.
Okay.
That is Odinandan case.
You refer to the paragraph of the judgment?
Paragraph 17.
17.
17 quoted, I want to point out. The Learned Council for the Appearance refers to two judgments heard in the post-granting compensation in state of New Jersey.
Para 17 is something else. The issue hardly poses any problem.
Leadership, there are differences in para because there are two copies submitted. One is from the Indian Canon and the other is from the SCC online.
I am
She's
seeing
probably-
SCC online.
She is reading from the.
She is reading from the Indian Canon, which was served to us today morning. Yeah, this I am forwarding it.
Is the para
Odinandan
17
Prasad also is the same department and the same point was raised for the acquisition, that is reinstatement and regularization. They also stopped from work in violation of the 25 years and the judgment was passed that was reinstatement and regularization is certain. So far the regularization is concerned on that when you consider the paragraph.
You just come to back wages. You focus on back wages. You
Backwards.
kindly focus on back wages.
Backwards. Then my lord, and there is evidence to prove that I was terminated not for non-compliance, and it is also proved that on the scheme, the 2586 I was on board. Therefore, my case is to be considered in the view of the Harinandan case, because on that day I was in service and I was legally terminated, and the benefit of the notification has not been granted to us. Those several vacancies was there, and several award was passed on that time, and they have given the reinstatement.
In Harinandan case also they were given back wages.
Yes. Hello?
When was the
And once
Harinandan
they
case? When was Harinandan
One-
case decided?
Yes. That is my lord. Paragraph 38. One, so for regularization of the applicant number 2 has been accepted for regularization, and so far the applicant number 1, the award for the statement is the acquisition. Because he was terminated much before the date of the circular. Respondent on considering the cases, that is case paragraph 37. Applicant number 1 was not in service on when the scheme was promulgated as on 6/5/1987. On that day, he was not in service. That's why the regularization cases have not been given to him. The only reinstatement is accepted by the particular. And the applicant number 2, 50% less, not 70%. They are giving reinstatement with 50% back wages, and the applicant number 2 has been giving 50% back wages and regularization. Because on the date of the notification he was on roll. Applicant number 1 was stopped from work about 4 years before the circular.
There the back wages was given to the extent of 50%. In Harinandan case.
That was award.
Yes,
That was award.
that's right. And you have been given back wages of 75%.
Yeah. And on my so far the back page is concerned, I want to refer, I'm sorry, the reference has not been given, that is 2013, volume 10, looking to 2013, volume 10, 3 to 4, paragraph 38.6.
This is which case?
And when that is Diwali, there was a
Is there any finding of unfair labor practice? Is there any finding of unfair labor practice in the impugned award? Is there any finding of unfair labor practice in the impugned award? No, I just want to know. I'm just putting a question to you. Is there any finding of unfair labor practice in the impugned award?
No, they have said that is discrimination and arbitrage. Discrimination and arbitrage. Because that is
Where is that finding of discrimination and arbitrary?
Yes, yes.
Kindly refer to that paragraph.
Yes.
Where is that paragraph?
In paragraph No, paragraph 8.
8.
8. The evidence of the management number 8 of 1 is minimal material. And 136, madam. Page 136.
Yes. You
Yes.
show me the word
evidence of
discrimination and arbitrary.
Next page. Considering the fact and circumstances of the 137, considering the fact and circumstances, it shows that when there is vacancy, there is circular vacancy by 1997. The management of the headquarters and the concerned workmen work for 90 days on 56. They should have been regularized because they have been worked for more than 40 days or 90 days in calendar year as per calendar. In the result, there is avoid the action of the management of food corporation in certain circumstances in different number circumstances with effect from 1856 and 1996 respectively in condemnation of the system and denying the reinstatement with food by wages and regularization with service as per the quarter circular. I told that. And whether it is
There is no finding of any victimization, nor the word arbitrary and discriminatory has been used as such.
When the evidence has been discussed, does they say that it is discriminatory when they
Kindly show me one word from the award that it has been held to be discriminatory and arbitrary.
democracy is the one who in the date of registration about non-observation and compliance resolution.
These are discussion of the evidences.
Yes,
There is
yes.
no finding recorded as such, madam. I could not find it.
Consider when the evidence has been discussed with the state, the civil weapon has been given. That is the civil person. Because permit me to read on the all the that is the short award. I mean this that.
No, we have read it. You just tell us. You said that there is a finding that it is arbitrary, discriminatory. There is no such finding that it is arbitrary, discriminatory. It was not proper, that is there. It was not justified, that is there. But there is no finding of victimization as such. And you have worked only for a period of 1 year, and you have been granted full back wages, 75% back wages. You have been discontinued in 1986. You have been discontinued in 1986 and regularized by the order in the year 2012. After how many years? 86. 96. After around 25 years.
My lord, the case is pending 2012 is the award. 2012 is the award. 12 years is pending before your lordship. That is the 2013.
You are enjoying 17B. You are getting 17.
Who is out of service is enjoying. I am very sorry to say that. He is not enjoying. And 25 days is not it is the statutory right.
The reference was.
I have known that there is no delay because I knew before this court earlier there is a direction by rejection order as far as I decided reference has been made 1990. But what is the delay on my part? And 98 reference has been made 2012. That is 12 years after the judgment award has been passed. I am responsible for that. 12 years, the case is 12 years, now 24, 12 years. This is pending. The workman and concerned are responsible for that. And that is exactly 2010 or 13 of the 24. That is paragraph 9 consider of permissive reading. That they give their backwards is not giving that is another punishment to the government. Therefore, they should not be, because in the 30, I am sorry, my name, I should not give the reference. 38, that is a small paragraph. I your lordship to permit I may 38.6. In a number of in that case also, when the there was the delay, so many majors were pending, and after that the package is unreleased. And in a number of cases, the Supreme Court has interfered with the award of the primary administration of the case on the premises that finalization of the litigation has taken long time, ignoring that the majority of the district parties are not responsible for such delays. Lack of infrastructure and manpower is the principal cause of the delay in the disposal of the case, and for this the litigation cannot be blamed or penalized. It will be amount of great injustice to an employee or workman if in denied acquisition because there is long lapse of time between the termination of service and the final order of reinstatement. And the court should bear in mind that the most of the cases the employee is in an advantageous position vis-a-vis the employee or the workman. He can avail the service of the best legal brain.
Yes, I will consider that judgment. Did Balu Gundu judgment will be considered?
Yes, agony and the sufferer, that is those who feel like the employee or workman, you can feel afford the luxury of spending money on a lawyer with certain amount of them. Therefore, in such a case, it is needed to adopt a course of the suggestion of the in work of the citizen, but they are entitled for the back. That has been. And also when the original society, that is the same matter, reinstatement and regularization. Those two connotation is there, and there is a direction for reinstatement and regularization. So for appellant number 2, because it was most time 4 years, about 2 years, and so for appellant number 1, only reinstatement is 6%. Submission and award is what and that is also correct on that they were on service, therefore they are entitled for the restoration. And this judgment is enough to say if they are idle because the statutory provision is there. They are not gainfully employed. We have bound to say this was the court on both, and they are not in service, whatever may be they are getting or they were getting in 70 years.
This is yours.
And this is covered by the district report, and there is no dispute on the date of the circular 2556 highest constitution, and we have completed 40 reports. And he has also said that there is no dispute. And there is several documents and evidence also, and the evidence of W1 is very important because it says for money appointment they were and he was regular. And so far the other award is concerned, that is not important. And sorry, that is the permission I made the synopsis of the
You can file your short synopsis by this Friday latest. We will not accept anything beyond Friday because the courts are closing, right?
yes.
Courts are closing.
But
Anything, whatever you want to file, you can file it as short synopsis. You can also file it, right?
We'll
But
file it.
nothing beyond Friday. I will not accept it. And don't send anything through mail.
Okay, we'll find
If
it.
your lordship, if your lordship to permit, my lord, I may give the photocopy of the exhibit, my lord. If your lordship
Yeah.
to permit.
You can just put the exhibit along with your whatever synopsis you are filing. You can just put it along with that.
Yes, madam.
That will be good.
Document as much of that.
लिखिए जरा. Heard the learned counsel for the petitioner. The learned counsel for the petitioner has submitted that in this writ petition, the common award passed in reference case number 21 of 1998 and reference case number 31 of 1998 has been challenged. He submits that in reference case number 21 of 1998, there are two workmen who are respondent number 1 and 2, and in the other case, there are 5 workmen who are respondent number 3 to 7. He has also submitted that the evidence in both the cases were common evidence were common. The learned counsel submits that the respondent number 1 to 7 claimed that they had worked during the period from 1/9/1985 to 31/8/1996 as casual workmen and had completed 240 days of service, but they were discontinued in violation of section 25 capital F of Industrial Disputes Act. Their further grievance was that the scheme of regularization which was prevalent in the establishment of the petitioner was also not given effect to so far as these workmen are concerned. The learned counsel submits that the workmen were claiming regularization by virtue of circular dated 6/5/1987, wherein the cutoff date was 2/4/1986, which provided that upon completion of more than 3 months on the cutoff date, the workmen were entitled for regularization. The learned counsel submits that audit petition being CWJC number 1947 of 1995 within bracket R was filed, which was disposed of on 15/7/1996. He submits that the industrial dispute was not referred, but it was observed that the workmen could file their representation in connection with claim of regularization. Ultimately, the representation was filed on 2/8/1998 and was rejected on 31/12/1998. It was the order of rejection which has been treated to be a cause of action for the fresh reference. The reference included the legality, the examination with respect to the violation of Section 25 capital F of Industrial Disputes Act and also the claim for regularization as per the circular. The learned counsel submits that the specific stand of the management was that these workmen never worked in the corporation, and the certificate which was issued by R.C. Sinha, the depot in charge, was itself not reliable in view of the fact that a departmental proceeding was initiated against him for having given false certification. He submits that that Sri R.C. Sinha was ultimately punished in the departmental proceeding. The learned counsel has further submitted that none of the workmen who are respondents in the present case deposed before the court. Rather, two witnesses were produced on behalf of the workmen. WW1 was the watchman who was not working at the relevant point of time and he had joined subsequently. And so far as WW2 is concerned, he was only a visitor to the premises and was not a co-worker. The learned counsel has further submitted that so far as the back wages, the learned court has also awarded back wages to the extent of 75%, although there was no evidence that the workmen were not gainfully employed after their discontinuation way back in the year 1986. He submits that he has referred to judgment passed by the Honorable Supreme Court reported in bracket 2006 bracket close 6 SSC 236 and ये किस लिए refer किया है? Paragraph 22
Back, no working pair.
to to submit that the principle of the workman the back wages could not have been
No evidence is there.
awarded in absence of any evidence that they were not gainfully employed. He has also relied upon the judgment reported in bracket 2019 bracket close 10 SCC 695 paragraph 26 and 27 to submit that in a award passed without any evidence, the award itself is perverse. On the other hand, the learned counsel appearing on behalf of the respondents has submitted that the two reference cases, though were clubbed and a common award was passed, but one writ petition was not maintainable. She has also submitted that the petition under section 17 capital B of Industrial Disputes Act was filed before this court on 27/7/2016, which itself reflects that the respondents were not gainfully employed. She has further submitted that the respondents were appointed on 1/8/1985 on casual basis, madam? On casual basis, and were stopped from working with effect from 1/9/1986, and the delay in reference which was made on 11/6/1998 is duly explained in view of the judgment passed in the case of earlier writ petition and subsequent representation and rejection of representation seeking regularization. The learned counsel has referred to Exhibit W-1, which was order passed in reference case number 94 of 1996, and has submitted that the petitioners were also entitled for similar relief. She submits that other persons were regularized and the petitioners were not regularized, and therefore the action of the and the respondents were not regularized, and therefore the action of the petitioner was arbitrary and discriminatory. She has further submitted that she has further referred to judgment passed by the Honorable Supreme Court reported in bracket 2013 bracket close 10 SCC 324 paragraph 38.6 to submit that that there is no illegality in giving back wages to the extent of 75%. Once the termination was held to be illegal, the reinstatement with back wages is a automatic consequence. The learned counsel has also relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2014 bracket close 7 SCC 190 Hari Nandan Prasad and another versus Employee Management of Food Corporation of India to submit that the said case also was arising out of the same scheme of regularization, and the respondent in the said case is the petitioner before this case now. She has submitted that in the said case 50% back wages was granted. The learned counsel submits that so far as the appellant number 1 is concerned, he was not in service on the date when the scheme was promulgated. He was given the relief of monetary compensation in lieu of reinstatement. Yeah, na?
Only out of two, only one was given regularization.
Yes.
The other was not working for 3
And
months.
so far as the appellant number 2 was concerned, he was given the benefit of the circular, as was given to other similarly situated employees, and he was held to be entitled to benefit of the scheme, he was entitled to 50% packages.
Regularization, more,
Yes.
more money.
Yes, and regularization. That's all.
Yes. And
Arguments concluded.
but the dates have been not properly.
Yes, tell me which date I have wrongly mentioned.
Yes, no, I'm going to say wrong. That is the rejection order which my lord again
31/12/98.
no 96. Rejection order 96.
96. What is the date of
Yes.
representation? Representation.
The representation date is not mentioned.
Rejection order is?
And it has been rejected on my lord 13/12/96.
Rejection order का date connect करेंगे. 13/12/96.
96. And another date, my lord, those one on roll on 2/5/1986. I think my lord.
Yes, 2/5/1986. I have taken those on roll on 2/5/86 and had completed 3 months were entitled to regularization.
Yes.
Correct?
Yes. And 25 days. And my lord, another reference, that is two references is exhibited. 94 of 96 and my lord 64 of 95.
Both were exhibited.
Yes.
Exhibit number. Exhibit number
So, yes, W1
and
and W2.
W1 and W2. W2 का नंबर बताइए. रेफरेंस केस नंबर.
Reference W2 का reference.
W2 का रेफरेंस केस नंबर बताइए.
Yes, my lord,
64 of
95.
64 of 95.
Both the references have been marked at exhibit W1. Both the references, two references avoided.
दोनों का एक ही नंबर.
एक
एग्जिबिट W1 में 2 रेफरेंस केस है. ठीक है.
Yes, ma'am. Yes.
अब कोई सबमिशन देने का जरूरत नहीं है. अब हम सब लिखा देंगे. जितना सबमिशन. नहीं, अब कुछ नहीं. हम आप लोग जो आप लोग सबमिशन किए हम सारा आपको कोर्ट में लिखा दिया. 5 को बच गया फिर भी लिखा दिया.
And AP number में जो राउंड हम दिया है. AP number 516 up to present.
Only Bundu Survase, if you are not submitting 38.3, Bundu Survase clearly mentions that a statement has to be made before the industrial adjudicator regarding gainful employment, not being gainfully employed.
जो भी आप we'll read the judgment and then record it.
So, Lordship, will file Lordship short
Nothing.
submissions?
Nothing.
And award was clear.
Anyways, if you want to file anything, you file it. But whatever you have argued in the case only that thing will be taken into consideration. Anything which is mentioned in your written submissions, which is beyond your arguments, I will not consider it.
And my submission is that so far that point is concerned, he has been punished. Punished that has not been argued before the court below and no.
Madam, we have heard you for 1 hour, more than 1 hour, both of you. Now you will just get the judgment. You can file whatever little short synopsis if you want to file by Friday. You do it. हाँ sir.
And all the exhibits are very important. My vacancy is also important. Vacancy is
We
there.
will see that.
And vacancy is at least before the court.
Appearance of
Otherwise,
CEO was
vacancy
there
is
for
not
assistance.
But the last order
Yes.
also, that there was a direction upon them to
Yes.
putting it to questions. And then direction that the circle officer shall attend
Yes.
to assist this court. And if they
They
fail,
never mentioned it. क्या आप करते हैं? 3 दिन उनका वेस्ट करेंगे ना? 3 days of a public servant.
Apology.
What is this?
I apologize.
they have filed their counter.
Yes, yes. Pursuant to the
Reply-
we have
reply-
filed.
to the queries of the
When
court.
there is a
Because that is not physical appearance, but
Yes,
only to
Your
assist the court.
Just to assist the court. In the-
कौन आए हैं? सर्कल ऑफिसर.
Lordship, give us any other date after. He will be here, Your Lordship.
If you are not there, he will mention it himself.
Yes, Lordship.
लेकिन 10:30 बजे रहेंगे, मेंशन करेंगे तभी आपका मैटर टेगा. ऐसे नहीं होगा कि
नहीं,
उठते समय मेंशन कर रहे हैं.
No, Your Lordship.
और एक दिन
I think
पहले भी
so.
बताएंगे कि he is
Yes.
about to come such that
Yes.
I also read the file and then
Yes, yes.
नीचे रहता है मैं इतना का मैटर पढ़ के नहीं आता WPC number 2381 of 2021. The concerned circle officer is present in the court pursuant to order dated 9/9/2024. But the case was not mentioned at 10:30 to enable this court to take up this case out of turn. The matter is accordingly adjourned. बताइए कब डेट बताइए.
Is there never any date, Your Lordship, as Your Lordship?
12th of November. 12th of November में उनको दिक्कत होगी. 11th November. फाइनल डिस्पोजल में आ सकते हैं मैटर.
Yes, yes.
हाँ.
11 November.
ये इसको सुन चुके थे बहुत बार.
अरे सब बहुत बार सुन के नहीं डिसाइड किया इसका मतलब
नहीं
बहुत
कुछ
है
ना कुछ
इसमें.
कॉल फॉर हुआ क्वेरीज हुई.
क्या बात है सर्कल ऑफिसर को लॉ नहीं समझ आ रहा ठीक से या आप समझा नहीं पा रहे.
फैक्ट मिलर दी
नहीं समझ गया
समझ गया. अभी को रिलीफ दे दिया क्या.
नहीं एक्चुअली दो प्लॉट है अभी तो आर्गुमेंट का दो प्लॉट है. एक प्लॉट में हम लोग जो है देरी
एक लव्य स्कूल बनाया.
हाँ ना और दूसरा प्लॉट
इना एक्वायर किया हमने जमीन
लगता है टाइटल सूट का केस है क्या.
हाँ लैंडिंग
नहीं टाइटल सूट बता दो लिखित में दे दिए.
ठीक है.
स्कूल स्कूल
उस दिन फाइनल
हम कहाँ बोल रहे हैं स्कूल तोड़ रहे हैं. हम बोल रहे हैं वो कॉम्पेंसेशन.
Yes, Mr. Niranjan, you are back to court. Are you okay now? Your matter was there. It has been passed over.
Yeah, I
You were not there at that point of time. कौन सा केस है ये? अब तो क्या ही करेंगे. परसों करेंगे. आप बताइए आपकी तबीयत ठीक है. आपका वेकेशन आप बताइए कौन से दिन करेंगे. जिस दिन आप बोलेंगे उस दिन 15 को पोस्ट ऑन 15. फाइनल डिस्पोजल में डाल सकते हैं. ठीक फाइनल डिस्पोजल आप आके मेंशन कर लेंगे आपका केस कर.
फाइनल डिस्पोजल में